Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here today convening the first meeting of the biennium of the Legislative Committee on Judicial Rules. As of yet, there is no chair that has yet been elected, which is why I'm convening the first meeting, which is a tradition that our office gets started with particularly a joint committee when no chair has yet been elected. So with that being said, the first order of business is the actual election of a chair.
So as the former chair of Judicial Rules, so Senate chaired the last biennium, and we are going to graciously pass it to the House for leadership. I would nominate State Representative Barbara Rachelson.
Exactly, and as Senator Clarkson explained, the tradition is that the chair position rotates between the Senate and the House. Senator Clarkson, being the chair last time, has now nominated for the chair role during the upcoming biennium, Representative Rachelson. Are there any seconds? I'll second that. Representative Lalonde has seconded the nomination. Are there any other nominations? Seeing none, I'll declare nominations closed. All those in favor of the election of Representative Rachelson as chair for the upcoming biennium of the Legislative Committee on Judicial Rules, please say aye.
Aye.
Those opposed, please say nay. The ayes have it.
Congratulations, Chair Rachel.
I know I need to get a catch up with you. Thank you.
I think you get a hat too.
A hat.
And a gavel. And maybe an embroidered shirt. And then we have to elect a vice chair.
Yes, next order of business is the election of a vice chair. Representative Rachelson, I can turn it over to you for that, unless you'd rather I do it, whichever you prefer.
You may do it. And then anyway.
Okay, all right. Next order of business is the election of a vice chair of the committee. Again, traditionally, that role has rotated. Last year, the vice chair, I believe, was Senator McCormick. Does that sound right? Or no.
It was me.
Senator Rachelson, that's right. So if you follow that tradition, then the vice chair this year would be a senator. So are there any nominations for the role of vice chair for the upcoming biennium?
I'll nominate, no, I'm not gonna nominate, senators should nominate somebody, I'm not gonna.
We just nominated somebody.
All right, I'll nominate Senator Clarkson to be vice chair.
Representative Lalonde has nominated Senator Clarkson. Is there a second?
Does she accept? I accept that nomination.
Senator, I heard Senator Brock, I think Senator Hashim also both second, so we'll accept that as a joint seconding. The nomination has been seconded. Are there any further nominations? Seeing none, all those in favor of Senator Clarkson serving as vice chair of the Legislative Committee on Judicial Rules for the upcoming session, please say aye.
Aye.
Those opposed, please say nay. And Senator Clarkson is elected the vice chair for the upcoming biennium.
A team, it's a hot.
Thank you, Senator Clarkson. Thank you, Representative Rachelson.
Thank you.
We will lean on all of you. LEA and in this committee as a plus.
So Eric, I know in the email that you sent, you mentioned reviewing the charter of the committee, which I didn't see on the agenda. And I know that people are tight for time. So I didn't know if that's something we could email out to people.
Certainly can, yep.
Okay, because I couldn't find it.
That would summarize exactly that, the constitutional provision and the statutory provisions that create the committee and outline what the committee's duties are. So yeah, happy to send that if that's easier.
And then we have a new member, because I think most of us have served before, but Ian, we welcome you as a brand new member.
Thank you, Vice Chair.
He's very excited to be here. We're excited to have him.
Nada, you were with us last biennium, right? Yeah. So.
Yes. So we do have 3 witnesses today. Is that right?
Exactly.
Yes. So in the interest of time, if people are fine with reading the charter and asking questions at the next meeting or emailing, we could move on to the horns beeping and having Alan Pease, who chairs the Advisory Committee on Civil Rules.
Aaron's online, yeah.
Yes. And we do have the horn is Good, thank you for. So the proposed rule was proposed back in February. Comments are due this upcoming week, and we have not yet reviewed it, which is something last biennium. Allison worked really hard to try to change it so that we actually had a chance to weigh in before things were adopted. So shall we turn it over to Alan to present?
Oh, Alan, there he is.
Okay, yes.
Thank you, Representative Richardson. Just one thing I would interject here to give the committee, refresh the committee's recollection about your role, depending on what status the rule is in. So right now, for example, you're looking at a rule that's still in the comment stage. Comment period has not yet been closed. So at this is, you'll see this perhaps when you look at the rules and the statutes that I send around. But the review at the comment stage by this committee is not something that's actually in statute. That's something that's been worked out as a way of comedy between the judicial branch and the legislative branch, so that you're not forced into the position of only having the opportunity to formally object. So the idea is that they give you the rules during the comment stage. You can look at them, you make any comments that you have, and then the court takes those comments back, and they'll either incorporate them by making an amendment to the rule, or sometimes they won't, and they'll come back at the subsequent meeting after it's promulgated, and they'll explain why they chose not to. But either way, you have an opportunity for input. So that being said, this rule being in the comment stage, your role here, your opportunity is to make any comments you think are relevant about the rule, about the proposal, so that the court can consider those when they promulgate them, which hasn't happened yet, at least not this rule, because it's still in the comment stage.
Thank you. That's helpful.
And when does the comment stage close on this one?
April 10th.
It's
It's on the agenda. It's on the agenda. It's not on
Oh,
the,
it's on the, okay.
yeah, it's not on the document, so.
April, we have a few brief days.
Yes, but fortunately, the promulgation date, even though that's when the comment date stays, typically the promulgation, there's another additional window in between the closing of that comment period. I'm not sure exactly how long that usually is. Maybe Emily would know, but it probably varies.
Depends on the court is going to be.
Oh, right, there you go.
Great. So Alan, do you want to present anything to us so that we can bond, especially for people that did not have a chance to look at this?
Good morning. Alan Kais, Chair of the Civil Rules Committee. We're talking about change to Appellate Rule 30, is that right?
Yes.
Okay. This is a corrective or a technical amendment. We found that in revising the appellate rules to reinstate the printed case requirement, the court had experimented with going without printed cases and relying on the electronic record. We found that we'd omitted the filing deadline. So this rule reinstates the filing deadline by adding a section into Rule 30, renaming Section E as the filing deadline for both the appellants and the appellee's printed case.
Thank you. Does anyone have any questions?
That makes sense. I think that is a good idea.
Great. So does anybody have any further comments that they want the judiciary to consider?
Wise move.
Looks good to me.
Wonderful. Okay. So do
Thank
we
you.
need a motion or no?
No formal action necessary. So when I draft the minutes, I will usually, as much as I can recall, and I look at YouTube is helpful with this, the minutes will say Representative so-and-so, Senator so-and-so commented whatever A, B, and C, and then just say the committee had no further comments or something like that. So
It made perfect sense.
So
I think I should.
So Eric, since it was so helpful for you to set the table on that one, would you like to provide background to the committee on our next proposed rule?
Sure, and actually, this one looks like it's in the same posture, which is a proposed rule, in the rules of, the probate procedure. And if I remember correctly, we heard from a couple of the witnesses, is it Judge Ertel that will not be here and Judge Kennedy will be
Oh, right, we did hear.
hearing? Does that sound right, Lindsay?
I think we have,
Judge Kennedy's not here yet, but can we skip to the third rule?
Yeah, absolutely. Yep.
Good, yeah.
Pardon me?
no,
Uh,
third rule, but
yeah.
Catherine Kennedy isn't.
but we're running
We're so speedy.
she's not supposed to be on until 12:30. So maybe she's.
Yes, okay.
Another one, didn't you?
So let's move on to the third rule. And
Also proposed,
also proposed.
again, just for comment from the committee, as
Like-
opposed to any formal objection.
And so comments are not, that they don't end until May 12th. So this is great timing. And we do have online, the Honorable Carrie Ann McDonald Caddy, the Superior Judge and Chair of the Advisory Committee on Family Rules.
Good morning, everyone. Are you able to hear me down here in
We have.
Bennington?
We can even see you.
Perfect. Hopefully you're not seeing my lunch that I'm about to have in a couple of minutes.
Well, that's okay. We're so hungry. We're just, yeah, we're right with you.
So
Welcome.
thank you very much. So I'm Judge McDonald Katie down here in the Bennington Family Division, and I'm the presiding judge here, and I'm the chairperson of the Family Rules Committee. We've been very busy in the Family Rules Committee, but this particular rule here that's up for comment is just to reflect probably an oversight in the rules applying to remote and the hybrid proceedings. So currently under the Family Rules, your relief from abuse order docket hearings where a family or household member is seeking an order of protection on behalf of themselves against another family or household member, those by rule are hybrid hearings, meaning that litigants, attorneys, witnesses, they can participate in person, they can be remote, or they can be a combination, meaning the attorney is in person, but the party that they represent is hybrid and participating remotely. And then it's really for the court, meaning the judge, the presiding judge, to determine whether or not they need to be in-person hearings. And that may be just difficulty with hearing someone by remote technology, or that it's just better based on the type of evidence anticipated to be presented needs to be in person. What the rule currently did not include is those hearings involving vulnerable adults, meaning an interested party or a vulnerable adult seeking an order of protection against a family or household member. That was not included in the Family Court Rule 17 to allow those hearings to also be hybrid and remote. Now, I don't know of any judge that would say, well, it's not in the rules, so it has to be in person. I think we're all using that flexibility of allowing parties and litigants, witnesses to appear remotely or in person based on the needs of those individuals and the needs of the court. And it's working really well. I think that it's increasing the amount of time of participation in hearings. And I think it's more effective also for individuals that are seeking order protection, that they're not necessarily in the same room with one another, meaning plaintiff and defendant. So I think it's been working very well, at least in Bennington. And so we're including in the amendment to just include those type of hearings. It is meant to be that they are also can proceed remotely, again, with the court having the ability to have in-person hearings, meaning to require it of those parties and those litigants and witnesses to be in person. And that's what it is. I did receive a comment. The comment was from Michaela Tucker, who is the general counsel for Athena Advocacy, which is a group in White River Junction, Vermont, as well as Victoria Lloyd, who is the CEO of the company. And they were just asking for the Family Rules Committee to consider including in that provision in Rule 17F to add hearings involving financial exploitation of individuals to be part of this hybrid rule as well, which makes sense.
Yes.
And vulnerable adults, it could be for abuse, it could be for neglect, it could be for exploitation. But the interesting provision of this statute that Ms. Lloyd and Ms. Tucker referenced, which is in Title 33, Section 6951 to 6953, actually refers you to filing an action in the civil division. So it's just interesting where, and that probably is because it doesn't require it to be between household or family members, which kind of brings you into the family division. It's just seeking a hearing on behalf of an individual who has been financially exploited by another. But I think the distinction is because it doesn't require it to be by a family or household member, just in general by any person. That section, that the comment, the attorneys that made the comment, it's actually in the civil division. So I think it would be for the civil division to take a look at. And I think actually it probably is already provided for under Rule 43.1 of the civil rules, allowing for hybrid and remote proceedings. Okay. So I think the concern raised by the attorneys is already provided in the civil rule, but I was planning to pass that along to Attorney Keyes involved in the civil committee.
That's interesting. I was wondering, many times the financial potential abuse could be a family member. So I don't know if that's what they were thinking of. And I'm wondering if the vulnerable adult also has counsel, does the rule cover that? Is it clear that counsel would be able to participate, or was that inadvertently left out?
Everyone could, meaning that
okay.
For your hearings that you're seeking an order of protection, an interested party on behalf of vulnerable adult or the vulnerable adult, him or herself, their attorneys, their witnesses, all of those people involved in those hearings could be either remote or in person under the revision of the Rule 17F. Which again, I think it was anticipated that they can, and I don't know, I've had a couple of cases involving vulnerable adults and they've always participated a combination of remote and in person. And I've never said, well, the rule doesn't include you, so it has to be in person. We've used the same flexibility. I think it's just recognizing this more formally in the rule.
Right. Questions?
Fine by me.
Or input? Anybody have any concerns?
No, that's good.
Well, I guess one question is, even though this is covered, it sounds like it's covered in civil rules. We want to make sure it's also, families may also be exploiting people financially. So, I don't understand why it wouldn't be additive to have it here as well.
So
it could be a family court issue. It could be it could just as easily be a family member taking advantage of a vulnerable senior.
This rule would cover those hearings, but the hearing that the attorneys raised in the comment, it requires an action to be filed in the civil division, and so the civil rules would apply, not the
even if it's a family matter.
It probably wouldn't be a family matter. That would just be the exploitation of a vulnerable adult by someone else. It could be the order protection would be in the family court through the proceeding of Rule 17F. So.
It seems so duplicative.
It might be, but in the family court here, I don't think it would be a family rule that would cover the particular statute because the statute requires the litigant to file the claim in the civil court. So it could not be transferred to the family court because we would not have jurisdiction over that matter.
That makes sense.
Well, is the question whether the legislation should change to have heard in the family division, or is there? Or I assume there's a reason why it's sent to civil division, or is there not?
Eric Fitzpatrick was on council. If I could jump in for a second, I think the distinction is there's no family member involved in this, in the site, the statutory site that they're referring to. That's an exploitation by maybe some person they've met or somebody online or somebody who covered
they're
What if
the
it's
fraud
you.
scheme or something like that. If it's a family matter, it's already covered in the jurisdiction of the family.
Okay, that wasn't clear.
Okay.
So if it's a family member exploiting a vulnerable adult, it's already covered.
Including financial.
Okay, that wasn't so clear.
No.
Including financial.
Including financial.
Yeah. Yeah.
Okay,
Which-
anything,
Right.
any bad
Okay.
stuff.
As
Okay,
long as it's between family members.
And it sounds like you were sharing that with Alan as well, who can see if they
Didn't
have
stay with
further
us.
thoughts. Right. Thank you. So I think,
I'm fine then.
great.
Yep.
Looks like we are all set. Thank you very much.
You're welcome. Nice to
Bon
see you.
appetit.
Thank you.
Okay, so on to our last rule, and
Catherine is not with us.
okay. Catherine is not with us. We can have Eric review it with us and see if Catherine shows up. Shortly.
I'm going to defer to your court witness on this one, Emily Weatherall, who can go over the rule, also a very
Thank you.
minor proposed rule, which we intentionally set up this first meeting to be short, but hopefully rules will be very straightforward. That small 3-page packet of what the rules are, one-time deal.
I know, yes.
Usually they're like
Prepared for reading,
Oh, yeah,
yes.
no, that's one of the best links that you've created for the last couple of years, that we just put on it, and the whole thing comes up.
I know, that's very handy.
It is handy.
It's super handy.
Don't have to have those huge packets of rules, so.
I remember.
I always print them all.
I know, I do too, but
I do too.
nonetheless, it is handy.
No, right.
Thank you.
There's a question.
We're so glad you're here.
So, for the record, Emily Weatherall, I'm the deputy clerk of the Supreme Court. Nice to see all of you. Nice to meet you. Welcome to the committee. You'll see my face here. So, I just wanted to just clarify one thing, not to, but that first appellate rule that you looked at, the comment period actually has closed on that rule. It hasn't yet been promulgated, so I will still take the feedback that you've provided, but the
You mean thumbs up feedback?
thumbs up feedback, I always appreciate that kind of feedback. More constructive feedback is always appreciated as well.
Yeah, work.
We're looking now at the second item, the second rule that's there on the agenda, and this is a probate rule 3B1B3. And essentially this rule is just
I know.
conforming the rule to a statutory change that was made. And so if you have really technical questions, I probably would defer those back to the probate rules committee, but basically there was a statutory change in Title 14. And if there is a situation where the court in this situation is going to be able to allow a petition to go forward without service on everybody, as long as all of the heirs and the surviving spouse are consenting. So because of that change in the statute, there had to be a change here in the rule that previously required service on everybody before they could proceed with that petition.
And that got increasingly complicated.
It got increasingly complicated.
They could be all over the place
Absolutely.
Not responding or,
and not responding.
right.
So I mean, I don't think that the rule is really doing anything other than making it consistent with that statutory.
Right.
um,
I think that makes good sense. Always nice when rules make sense.
It is nice.
And that they're in conformance with the.
And that they're in conformance with our work. Yeah, we appreciate you.
So we have questions?
Yeah, well, I'm just, so is that the big probation law rewrite that we did, and we're just kind of catching up with some of those changes?
I do not know that off the top of my head. I'm sorry. I don't recall when that was made.
2 minutes.
I don't think if the question is it like this past session? I don't think so.
No, it wasn't this past.
Yeah, that's what
No.
But we
I'm
had
not
a major overhaul of all the
Right.
probation law, and I'm trying to remember when was
Right.
that?
3 years ago.
22 or something, like, yeah, anyway.
might have been part of that.
Tell you in a minute here.
No, it's not that important.
I mean, on the one hand, it is interesting to see how long does it take for the rules to change from when a statute is passed? I mean, and how do we address that if they're, and I mean, this one,
So it looks like that one was effective 2020.
2020,
Ooh, a long time.
it is. I mean, and granted, we had lockdown, but still.
Fair.
I'm just trying to remember.
Still, that's 5 years.
But maybe that is a question we should ask each time because we need to
Speed that up.
speed that, like figure out ways to, right, speed that up so that
Maybe
it
we just
happens.
ask Emma, why do you think it's such a lag?
I don't want to speculate as to this particular example. I do know that we've had conversations over the years between Ledge Council and the court in both directions. In other words, sometimes there are decisions or rules that say maybe the legislature should consider change to a statute. And then there are also sometimes statutes that implicate rule changes. When they're very obvious, we pick those up. But sometimes there are changes
That
that
may be a little long.
take a little bit longer to do, yeah.
And maybe it's a good question, right? That, yeah, thank you. That's. So if you do end up hearing anything related to the time lag, that would be helpful just for our informational purposes and trying to see how we can work in tandem to expedite the processes.
Sure, I can ask the chair about this situation in particular, yeah.
As a new member, so do these come about, the changes, when an attorney runs into it and it's like, why is this like this? And then it sort of goes through the process.
Yeah, great question. I don't know as to this particular rule, how that got instigated. But the court, as you can hear, the court has advisory committees in each area. So advisory committee on civil rules, family. And often the rule changes are instigated because someone on the committee was approached, or the committee chair was approached by an attorney or a litigant that said, hey, this rule, either it doesn't conform with current practice, or there's something about it that I think we should change. It's inconsistent with something else. I found, so yes, often those are because.
So could the delay just be that it took some time for somebody?
It could be.
And it certainly can be a question we ask of like, how did this come to the attention of this committee? Because that might be interesting. And I'm wondering if it makes sense to spend a few minutes at the next meeting to talk a little bit more about not just the charter, but how things.
The progress. So change
Right.
statute, then
Yeah.
how does it progress
Right, like-
through rules, and
Right.
how might there be that lag of 5 years?
Right, because I don't think we did that last biennium either, and I
We focused
wondered
on-
some of those things as well, so great. So any other questions for Emily?
Eric?
Eric Fitzpatrick, Vice Counsel, just one thing I'd add to that discussion, because it's interesting, it's happened over the years, as Emily noted, in both directions.
Yeah,
And sometimes the court will issue an opinion that says, this is a matter for legislative action. It's
Right.
not something, it's not something for the judiciary to rule on. It requires a clarification of statutes, something of that nature. So it can happen in that direction.
right,
And sometimes the legislature responds to that and sometimes they don't. And I don't think it's intentional necessarily.
Yeah.
So it's always been talked about. It's an interesting idea that, is there some way to formalize
right.
that communication, other than, Emily and I do our best in sort of a back channel kind of way to let each other know when we hear about something, but I don't know. But I think some states have, maybe committees of.
That
We
look
don't
at
need
that.
another committee.
But it is interesting to look at because I was reading a decision on a bill that I sponsored that got challenged, and there were recommendations for legislative changes in it that until I happened to read that several years later, I had
Right.
no idea. And we should try to look at how on our end we can do what we can to address what the judiciary is raising. Yeah, so should we put that seems like a great discussion for next.
Good idea.
Sometimes the legislature has directly amended rules.
Yeah, I was thinking of directly amending Rule 75 for fun. But I'll take that up with Eric later.
I'd like to directly amend a bunch of rules, but I like restraint.
But I'm kind of wondering, maybe, well, I don't know if you give, so Rule 75.
You have to give me notice if you're gonna want me to talk about these things.
That's the mandamus rule, and I was wondering, it'd be a little, maybe it would be odd if the, the legislature is trying to strengthen the mandamus rule to keep the executive branch in check through the courts. That seems uncomfortable to me somehow, that maybe it should just be the courts that deal with 75. You don't have to comment on that right now.
Interesting, though.
We need to sit it on the advice of council. So you can.
I'm taking it all in.
Yeah,
Me
she's in
too.
a listening mode.
Yeah.
Great.
Sorry.
Well, thank you. I think we have no other questions and no other
We thumbs up on that one.
thumbs up
Yes,
and
thank you.
I'm curious about the timeframe.
Yeah,
Always nice to see all of you. Nice to meet you.
Emily, it's always a pleasure.
I didn't bring cookies. Terry's not here, so.
That's okay.
Oh, can I do something to take back for Terry though?
Okay.
Right. No, the plastic box. Well, we adjourned.